Hello everyone, welcome to Let's Crack UPSC CSE English. About me, I am Sandeep Bhushan and my credentials are I have 8 years of teaching experience for civil services. I teach international relations, internal security and in-depth analysis of the Hindu editorials and articles, which will be definitely useful for prelims as well as mains examination. So this video is in regards to how to crack prelims 2020, but prior to that we'll go ahead with the subscription, and then Nikhila has joined. Good evening Nikhila. Brinda Armugaraj has also joined. Very good evening both of you. I would say hi to both of you also. And before that, you have a notification in regards to Let's Crack UPSC CSE English, wherein it is an India's largest learning platform, and once you subscribe, you will have access to unlimited live and recorded courses from India's best educators. Manish Rathod has also joined. Ravi Raj has also joined. I would say hi to both of you. And you have other privileges once you subscribe to the Unacademy Let's Crack UPSC CSE English channel. You will have the daily live classes. You will also have the live test and quizzes. You will have the structured courses, and along with that, you have the unlimited access to all the courses what you subscribe for. And these are the top educators of Unacademy, wherein you can have a glance on your screen. And these are the others who are also the top educators of the Unacademy platform. And in regards to Let's Crack UPSC CS English, you have the courses like polity, geography, current affairs and various other courses also, which are all being visible on the screen, or the various courses for UPSC CSE English channel. And for Let's Crack UPSC CSE English channel, you also have the other courses like governance, Indian society, CSAT paper, and also interview preparation, along with all other courses which have been visible on your screen. That is in regards to the courses for Let's Crack UPSC CSE English channel. And in regards to the subscription, you have 12 months and 24 month subscription. In regards to the 24 month subscription, the amount, the original price is 48,000. But when you subscribe using my code SBT10, that is Sandeep Bhushan Thummala 10, you will get a discount of 10%. And once the 10% discount is applicable, then the discounted price for 24 months would be 43,200. So please go ahead with subscribing for 24 months, because there is an privilege to the subscribers, that is they would be paying or else you would be paying only for 13 months, that is 40,000 plus 800, but you would get the subscription for the entire 24 months. So here is the opportunity. You can go ahead with paying only for 13 months, and then you can go ahead with the subscription for the 24 months, because it is as well it is clear that for civil services preparation you require solid 2 years, that is 24 months of preparation. And here you would get 24 months of subscription only paying for just 1 year plus 1 month amount you will be getting for the 2-year subscription, which is very important for the civil services preparation to be part of the serious preparation. So thereby you go ahead with subscription for the 24 months. If you haven't still subscribed, please do use my code SBT10, that is Sandeep Bhushan Thummala 10, to get 10%, and the amount would be 43,200. And then make sure that you take the maximum benefit, and please do inform your friends who haven't subscribed. Let them be part of the UPSC CSE Let's Crack subscription. Also, they will get access to not only my classes, but also in regards to the various other educators who are coming up with various other courses in the Unacademy subscription. So now we'll get into the in-depth analysis of editorials and articles of the Hindu newspaper, wherein this video or this session is in regards to the First, prior to getting into the topics what we would discuss, I would make you understand the importance of the in-depth analysis of the editorials and articles, or else the Hindu newspaper. The importance is that we need to make sure that we are all understanding the editorials, articles, and also the contemporary issues. Not only understanding, but you should be in a position to analyze the topic, analyze the issue, analyze what the experts are saying in regards to the prelims analytical point of view, and also in regards to the mains descriptive point of view. And this session, my class will definitely make you understand that in regards to the better and thorough analysis and understanding about the editorials, articles, and the contemporary issues, which will be certainly useful for the prelims, factual, analytical, and also mains point of view. And then hi to everyone, Malvika, and also Nikita has joined. Hi to everyone. Raviraj has joined. Manish Rathod has joined. Everyone, hi to everyone. Good evening to you all. And then today topics to be discussed is lockdown and online judgment or justice it is. And then you have even political detention, and also in regards to decentralization of powers, which is very important in regards to the prelims and also mains point of views. To start up, we will get into the topic that is today's topic, today's article, which talks about the lockdown and online justice. So this is the article, today's article, which talks about, or the heading of the article is accessing justice online. So we are all aware because of the national lockdown, and which wherein the Prime Minister of India has also extended further to May 3rd, and then the extension has been extended for almost this month, and then off of the first week of the May month also. So it is very clear that the way the national lockdown has taken place for the last 3 weeks, there was not any kind of delay, or the justice or the judiciary was functioning. So the functioning of the judiciary was going on. That was in spite of the lockdown, the functioning or the judiciary or the justice system has delivered the justice, or judiciary has delivered the judiciary has delivered the justice through the online process. So this is very important, through the online process. So not only that, all the formal employees were working from home. As we all know, the education system has also begun at a very high pace in regards to the online classes. Not only that, we have also seen that judiciary is also going ahead with the online justice. So this is very important in regards to the prelims and also mains point of view, because we have seen that one of the high court in India, that is the Kerala High Court, has created history. So when it has created history, so definitely it is an analytical point of view and also factual, wherein we need to focus from the prelims point of view. So it is the Kerala High Court on March 30, 2020, which has created a history in regards to what? In regards to conducting the proceedings. So the proceedings have been taken up as it was going on earlier also, before the national lockdown because of the pandemic COVID-19. The Kerala High Court has gone ahead with the same kind of conducting the proceedings, but this time the proceedings was not normal as it was, but the proceedings were in regards to the video conferencing. Proceedings were in regards to video conferencing and live streaming of the proceedings. So the entire proceedings have been taken up by the Kerala High Court, and it has created an history by going ahead with the video conferencing and live streaming. And this is very important because many a times there was an attempt made wherein the courts, it could be the high courts and the Supreme Court also, that there should be video conferencing, there should be conferencing, there should be live streaming of the proceedings. This was the need of the hour, when many of the courts across the country and also Supreme Court was also thinking about this, because it is very clear that in regards to the transparency, the Supreme Court, that is the judiciary, also has come up with many a time that it will go ahead with the video conferencing and also the live streaming, because this is the need of the hour, wherein it is a reformation or reforms in the judiciary system, and also in regards to the making sure that there is transparency in all the proceedings which are being taken up in the Supreme Court or in the High Court. So now this has been created. I mean, Kerala High Court has created an history by going ahead with the video conferencing and live streaming, which is making a president to the entire high courts of the country, I mean, to the states and also to the Supreme Court, that there is a possibility that we can go ahead with video conferencing and also live streaming whenever the situation is arising, that there has to be a transparency made, and when people or else the various sectors of the people, it could be the civil liberties, or else the activists, wherein they are demanding the video conferencing, wherein they were demanding the live streaming of the proceedings. So that is very clear now. The demand is almost a reality. The demand by the civil activists, by various civil liberties, that the demand has been now the reality because of the high court, what it has created in history. Because of the national lockdown, a history has been created. Please do understand the linking here. Because of the national lockdown, because of the social distancing, a history has been created by the Kerala High Court, wherein it has gone ahead with live streaming of the proceedings and also in regards to the video conferencing. So these two are important, these two keywords, that is in regards to video conferencing and then the live streaming. These two keywords are very important in regards to the factual prelims point of view, in regards to the Supreme Court verdicts or Kerala High Court, or in regards to the way the judicial reforms, or the way the kind of transparency is actually coming into the forefront by the Kerala High Court, and which can be implemented across all the high courts in the country and also in the Supreme Court. And the judges have conducted what they have conducted. We have seen the live streaming and the video conferencing in the proceedings. So what kind of proceedings have taken place and how the process have taken place, we will look into it. The judges have conducted hearing from their respective homes. So we have seen the entire judiciary system, that is the judges, they were sitting at their respective homes, they were working from home. So definitely it's, I mean, the judiciary is also working from home, not only you, me, and then in regards to the education system, or in regards to the formal sectors, IT sectors, IT enabled sectors, but also the judiciary is also working from the home. So making it very clear that the judges have conducted with going ahead with working from the home, and they have almost taken 30 urgent matters. So this is very, very important in regards to the taking up the matters, that is 30 urgent matters were taken up for hearing, including in this 30 urgent matters there were bail applications and also the writ petitions. So this is very important in regards to the prelims point of view. If at all there is a question made because the Kerala High Court has created in history in regards to the live streaming, so which among the following statements are wrong? So one of the statement can be based on the online justice by the Kerala High Court taken up the initiative, that the Kerala High Court has taken up 30 urgent matters, and then amongst them including the 30 urgent matters were the bail applications and also the writ petitions. Please do understand, these are the writ petitions. As a civil servant aspirants, you are all well aware of the writs, how many kinds of writs are there, and then the court working, I mean the judges who have conducted the proceedings in regards to the live streaming, sitting at their respective homes, have gone ahead with the bail application, going ahead with the prelims point of view in regards to the analytical point of questions. So the advocates here also, advocates concerned, so the advocates and also the law officers have also been participated into the video conferencing and the live streaming which has taken place. So we have seen the judges, they were sitting from the homes, the advocates, the law officers, who were all part of the proceedings and from their respective offices. So they were working from the homes, the judges, few of them were working from the respective offices. So look at the coordination, what is going on here. So there is definitely a reforms which is taking place, and the reforms which is happening in the Kerala High Court is definitely making a precedence, or it is showing a kind of system can be placed into by the taking example of the Kerala High Court. And definitely this is going ahead with a new concept called as e-court systems. Please do understand now, this by working from the home, that is video conferencing and the live streaming of the proceedings, is creating a kind of new system, that is in regards to e-court system. So before I just move further, Malvika Sajivan has joined, Nikita Kumari has joined, and then Madhu has also joined. Everyone, a very big hi to everyone, and then I will move forward. We were looking into the national lockdown and then the judicial proceedings, and now because of the video conferencing and also in regards to the live streaming of the proceedings, e-court system will definitely come into existence. So how you can look at it in regards to the prelims point of view and also in regards to the main point of view is this e-court system, or else the kind of impact of the national lockdown onto the judicial system. So the impact of national lockdown onto the judicial system, or because of maintaining the social distancing to contain the COVID-19, the new emergence or else the reformation in the judicial system, that is in the judiciary, is that a new concept or a new system, that is e-court system. Please do understand, this is a new system which is evolving, and this is blessing in disguise. So disguise is what? We are all forced to sit at home because of the national lockdown. The other side of it is unemployment is growing. The migrant workers, the daily wages are losing the jobs. But the other side of it is, what is happening is there is transparency which is happening in the judicial system. A step further wherein transparency is taking up, that is in regards to the video conferencing and then the live streaming, and that is actually heading towards, it is creating a platform in regards to a new concept or a new system called as e-court system. This is very, very important for prelims and also for mains point of view. So if you wanted to go ahead with a new concept or the reforms in regards to the judicial system, with coming up with the e-court system, what the government has to do is that the government has to establish an effective task force. So first and foremost, the government has to make sure that the government has to establish a effective task force consisting of what? So this task force has to come into existence. So the task force has to come into existence to make sure that the e-court system would be in practical, would be a reality which would take place. That is wherein again the transparency comes into the picture of the judiciary, video conferencing and then the live streaming. So this task force should consist of the judges. Please do understand, this is again very, very important when I'm talking about task force in regards to e-courts. This could be an analytical question in prelims, wherein it wanted the task force to be consisting of judges, technologists, court administration, skill developers and system analysts. Why all these are required? So you require a task force. Task force has to be taken into existence, or it has to established, and in the task force judges, technologists, court administration, skill developers and system analysts have to be part of it, because they would definitely draw a blueprint for what? Institutionalizing online access to justice. So this is very important, a key phrase or key statement is itself. I would say this as I would repeat a statement saying that the national lockdown has created a concept of institutionalizing online access to justice. The national lockdown has created an institutionalizing online access to justice. Explain. Are you getting my point? Please tell me yes or no. This could be your mains question. Based on the backdrop of pandemic COVID-19. So look at the COVID-19 impact on the judiciary itself. COVID-19 and its impact on judiciary itself. So I would repeat once again saying that the national lockdown has created the path or a platform for institutionalizing online access to justice. And the question could be in the mains, comment or discuss or explain. Okay, very good. Brinda says yes sir, so very good. So this is what you have to focus on. The reason why I am trying to take up an extra effort to make you understand that it is all important how you look at it. That is from the prelims point of view and also from the mains point of view. So this could be a very good key phrase or key statement itself for the mains point of view. And this task force will be charged with the responsibility. It will have a responsibility to establish what? Hardware, software and IT systems for what? E-courts to function or e-court system to come into reality. So first there has to be a task force which has to be set up, which would be consisting of judges, technologists, court administration, skill developers and system analysts, and that is actually creating a blueprint for having a platform or having an institutionalized online access to justice. And this task force will have a responsibility in establishing hardware, software and IT systems for making sure that the ecosystem would be in practical. And along with this, there has to be an artificial intelligence also. When we are talking about ecosystem, definitely there has to be hardware, software, IT system along with that. Added to that, and we should also have an application of artificial intelligence. So this is very important, artificial intelligence, because it will be benefiting the database which is generated by the e-courts project. So when we are talking about the e-court project, definitely it is through the online. When it is through the online, it is very important that the database has to be maintained, generated, maintained, and then that applications have to be under the control of the artificial intelligence, because the ecosystem possesses or it requires or it demands all this through a task force, and that task force has the responsibility of making up all this. And not only that, in regards to the artificial responsibility, but there has to be an appropriate e-filing systems. Why? Because there has to be an e-filing system. The one who is actually wanting to go ahead with submitting the petitions or plead, they have to file, and that e-filing system has to be into existence because of the e-court system when it wanted to be a reality. And there has to be procedures and creating skill training. So not just having an what you say system in place, but there has to be a skill training for all the, it could be the judges and it could be the court administrators and also the clerical staffs, that is the administrators who would be working in the e-court system to be a reality, that is would be part of the task force to make sure that the e-court system would be a reality. And once this entire task force or the entire blueprint, that is the institutionalizing of online access to justice, this one is ready, then the high courts across the country, so what they will do is they will refer this blueprint, the high courts will further refer this blueprint to the rule committee of the high court. So please look at it again, this is very important for prelims point of view in regards to institutionalizing online access to justice. So once the blueprint is ready, the blueprint will be provided by the high courts, it will be referred or it will be sent to the rule committee of the high court. So it is a rule committee which will actually frame the appropriate rules. It is a rule committee which will frame the rules for the e-court system, so that the operationalize or institutionalizing of the e-court system will come into existence. So please do understand the importance of all this procedure, which is part and parcel of e-court system, which is definitely an prospective question for prelims and also for the mains point of view. So the entire blueprint will be passed or will be given by the high court to the rule committee, and wherein the rule committee will further go ahead with framing appropriate rules to operationalize or to make sure that the e-court system will be into reality. So this is in regards to the lockdown and online justice. Please look at, please, because of the lockdown, online justice or else e-court system is coming into reality. And not only this, in this regards, there is a point which is also mentioned that the court, because of the national lockdown or because of or else once the e-court system comes into existence or a reality, there has to be not, I mean there has to be wherein the court should not just look at the pleas and petitions or the the suo motu cases taken up by the courts or the petitions filed by individuals or civil liberties or by any kind of person who is responsible to go ahead with taking up the responsibility to file a petition. But what is important is the duty of the courts is also being mentioned here. So the duty of the courts are the facility what will come up because of the access to the justice, that is to the e-court, what the accountability of the welfare schemes. The court should also look into the implementation, accountability and the transparency of the welfare scheme. So that is what is the need of the hour, what the author is trying to say in regards to the courts and welfare scheme. Now we are finished in regards to the online lockdown and online and also in regards to the e-courts. Now we are coming into the e-courts versus welfare scheme. Probably you may or may not gone ahead with looking at the what do you say courts versus the welfare schemes. It is all courts versus the petitions. It is all courts versus the petitions. But here we are looking at or we are emphasizing on the new what is a type or a concept, that is courts and welfare schemes. So it is the duty or the responsibility of the courts to make sure that the welfare schemes are implemented in a true spirit. They are going ahead with I mean, the accountability has to be also taken into consideration, and also there are no, I mean, it is with transparency and no corruption is taking up. It's the duty of the courts. So the facility must not only enable access to courts. See, look at here. The facility is not only just enabling access to courts, but what is important is the courts should provide access to justice. This is very, very important, and this could be a question in the mains also. Please do understand. The question could be in this way: the facility provided by the courts should not only be as access to courts but must provide access to justice. Comment: the facility by the courts should not only enable access to courts. You please emphasize on this: access to courts, but must provide access to justice. Only when you understand these two key phrases, then you will understand the entire concept here. Or else it will be just you are listening, and then at the end of the session, nothing, I mean, you wouldn't be maximally benefited by my lecture. What you need to go ahead is emphasize on these two key phrases. Access to courts is different, access to justice is different. Please do understand. Access to courts is different, access to justice is different. So what the facility has to be provided is not only enabling the people to have access to the courts. That is not at all what you said the duty or the responsibility of the court. What the reformations or the reforms to the judiciary system is that it must provide access to justice through other process also, to other processes also. So this could be your mains question, and could be they could ask you to comment on it. So definitely. And then the government, both at the center and the states, they know that there are many welfare schemes or poverty alleviation and distress eradication schemes. So the courts, the governments, the center, the states, everyone knows that there are many or various programs taken up by the states and the central government to go ahead with the poverty alleviation, and also in regards to the benefiting the beneficiaries or else the vulnerable sections or the below poverty level people, making sure that there would be out of the distress or the eradication of the distress is taken up by the welfare schemes to the below poverty line people, or in regards to the vulnerable section of people. And what is important here is a system must be set in place. So for this, what is important is to make sure that it is not just enabling access to the courts, but also access to the justice is important. And what should be in place in regards to the access to the justice is there has to be a system. Please do understand here. Now we are coming to the actual point, and a system has to be set in place wherein it will enable not only to access to courts but access to justice. So what the system has to be is that the system has to have an online complaints, or it can, so the applicant can go ahead with filing an online complaint in regards to the e-courts and the welfare schemes, and this can go ahead with, or this accessing of these schemes can go ahead with the legal services authorities. So definitely in regards to the e-courts, when the applicant is filing or lodging a case or lodging a complaint or petition online, so that would be taken up by the legal services authorities, and they will focus on whether the scheme, whatever the patient. And in addressing this accountability and implementation, you have an act. This is very, very important for prelims point of view. That is Legal Services Authorities Act 1987. So this is, you have an act for the implementation and accountability, wherein the online complaints are being filed for the accountability and implementation of the various schemes, poverty alleviation and distress eradication schemes taken up by the center and the states, and that is in regards to the Legal Services Authorities Act 1987. And this will actually deliver any kind of grievances or the complaints filed online by the individuals, and that will be on the basis of time bound manner. And what are the other facilities? What you say the e-courts can go ahead is online meditation, or there could be any kind of arbitration whenever it is necessary, and whenever there is a necessity that on counseling has to be done in regards to the family courts, and whenever there are definitely a quick settlement which has to be taken up because of the disputed insurance claims, because of any insurance claim or disputed which has to be settled as quick as possible. So all these facilities, that is e-courts or e-court system, can be get into existence, and then it can move further very fast, that the system, online system, comes into existence with a faster pace, and which will be useful for the entire people who are in need. And then we will conclude this by saying India is a land where skilled human resource is rarely lacking. That means India has the human resource, that is the youth. Almost 60 plus 65 percentage of them are the youth, and amongst them what the government is actually going ahead with using the human resource, they wanted to skill, they wanted to go ahead with providing the equipments, that is in regards to that the entire human resource is skilled by the skilled resources or the skilled processes, that they wanted to make sure that the entire country is rarely lacking the skilled human resources. And yes, India is a land where skilled human resources are rarely lacking. That means we have more of skilled human resources. If we have the willpower, then justice will become an accessible concept to everyone. This is very, very important, because of the skilled human resources whatever we have at this moment, what India is possessing or constituting, and only one what is lacking here is not the human resource but the willpower. So if we also have the willpower, definitely justice will become an accessible concept. That is what we have experienced at the time of national lockdown. We have seen that the online, that is video conferencing, and also in regards to the live streaming has taken place. E-court system is also bound to take place, and because of that there could be online mediation, online arbitration. Counseling also can be taken up wherever there is necessity in regards to the family courts, and whenever there are supposed to be taken up quick settlement in regards to any disputed insurance claim, then all this can be taken up through the skilled human resource. And what is just lacking is the willpower. And this is also the conclusion statement is also very important for the mains and also prelims analytical point of view. So you have many questions for prelims also. It all depends when I'm actually explaining, and then how you are actually emphasizing or focusing on the key phrases. Whenever I'm saying this is important, so it is always necessary that you need to focus on those areas for a better prelims 2020 or mains 2020 to score more higher marks. And this is in regards to the lockdown and online justice. Now we'll go to the second one, wherein I will take up this point and this topic, that is decentralization of power. Will take up. I'll take up the decentralization of power, and the one which I skipped, probably I'll take up whenever it is, what do you say, definitely to be taken up or required. It is required, but whenever the time is apt, I will definitely go ahead with taking that. But now we will look into the decentralization of power. This is an article which was couple of days back, but it is very, very important in regards to the decentralization of power or separation of power or federal structure of India in regards to polity prelims point of view, and also in regards to the mains point of view. And then the heading was needed, or what is needed is greater decentralization of power is required. That is what the author is talking about. And then I have taken the heading as the decentralization of powers. So we will look at what kind of decentralization of power is important at this juncture. So as we all know that because of the COVID-19 or pandemic, we have seen the entire country under lockdown, and then even our Prime Minister Narendra Modi has extended it further up to May 3rd today. This morning, 10 o'clock, he has gone ahead with the addressing the nation, and then the national lockdown is extended further. So when it is extended further, definitely it is required that we need to focus on the decentralization of power now, because the entire country is under national lockdown, and because of the national lockdown, we have seen, or it is that the government, state government and also the central governments have invoked many acts. For example, Disaster Management Act 2005, and also in regards to Epidemic Diseases Act 1897, 1957 also, and also in regards to the Essential Commodities Act and the section 144 of the IPC, and then Criminal Procedures Code. So all these acts have been invoked. So when these acts have been invoked, so definitely what kind of scenario is going up, or what kind of scenario is happening between the states and the center? Is it that the states and the centers are working in tandem to counter the pandemic COVID-19, not only to counter the pandemic COVID-19, that is in regards to handling effectively the health crisis, not only handling the effectively the health crisis, but also what is important is how best the states and the centers are together would handle the economic crisis of the country. Please do understand here, would handle the economic crisis of the country is also very important. Health crisis and the economic crisis, how best both the states and the center can come together and then handle the health crisis and the economic crisis, and make sure that they are both are working in tandem for the betterment of the entire country, entire the 1.3 billion population. So we have seen that Maharashtra, Kerala, Tamil Nadu, Rajasthan and Karnataka have gone ahead with implementing their policies, wherein they have gone ahead with implementing or framing their policies so that it would address them directly or through the whatever they have concerns in regards to the locally. So taking up their local concerns and then taking up that issues with what they have particular to that states, these states have framed or shaped their policies to deal the COVID-19 or to deal the health crisis or to deal the what do you say even a little bit of economic crisis. So what is important is that the powers or else the powers of the state governments to frame their policies as per their requirement, as per their demand, that they have framed their policies in regards to the lockdown. And we have seen that one of the instances, before the union government has invoked Disaster Management Act 2005, please do understand here, before the union government has invoked the Disaster Management Act 2005 on the backdrop of the COVID-19, many states have triggered, that means they have invoked the Epidemic Disease Act 1897. Please do understand here. And they have also installed a series of measures how to combat or how to what do you say come out of this COVID-19. That means definitely the states are also having powers. Please do understand here why we are taking up this example of Disaster Management Act 2005 and then invoking by the states or triggering, or else they have come up, the state governments have come up with Epidemic Disease Act 1897. They have installed, they have gone ahead with, and they have also gone ahead with various measures. Not just they were looking at the center and then they were waiting for the directions to be taken up by the states. No, they have gone ahead individually and then they have taken up all the steps to make sure that they would contain the spread of the virus. The individual state governments have taken up. That means definitely there is separation of power. There is decentralization of power. The states also have powers to make sure that they shape their own policies. Now, in this regard, when we are talking about shape their own policies to contain the spread of virus, to make sure that they can also effectively, with the center's help, they also can frame the policies, measures, and then they can effectively handle or combat the COVID-19 pandemic. So definitely there is the powers which are also by the states, which are being implemented by various states, not just looking at the center for the direction. So definitely the states are also going ahead with the or making use of the decentralization of powers between the center and the states are involved in. and they have, I mean, the states have communicated their decisions to the public, that is to the respective citizens of the states, with clarity and consideration, that they are going ahead with a broad framework for the nation, also helping in the process to lay out for a broad framework. So here when we are looking at it, is very very important that the state governments are definitely gone ahead with shaping their own required demanding policies at that moment. Not only by going ahead with that, they are also communicating effectively the people of the particular state that how they have to contain the spread of the virus, and also making sure that what necessary steps the state governments or state machinery will take into action if anyone is not going ahead with maintaining or strictly following the social distancing to contain the virus COVID-19 pandemic. But also they have laid out a broad framework in trying to help the entire nation itself. So definitely the states going ahead with shaping their policies and shaping their individual demand policies as per the local demand, as per the respective demand of their necessity. They are in turn helping the nation also. So they are working in tandem, states are working in tandem with the center, and by doing so what they are doing, what they are going at is they are acting not merely as a laboratories of democracy. And this is very very important for what do you say prelims and also mains point of view. This key phrase, states are not just the laboratories of democracy. Please do understand. States are not just laboratories of democracy. If there is a question or asked in the prelims or in mains, they should not get confused. Laboratory in regards to the what we were talking about, the what do you say, the medical research laboratories. No, here he is trying to compare that they are not a kind of been acted upon or acted upon the directions of the center. No, the states are going ahead with the way they are wanting, or the way the state demand, or the way the local issues are, the way they have to handle the local issues. So it is very clear that they are acted not merely as a laboratories of democracy. That means they also have definitely some kind of role or power to play. And who has, and also quoting here, who has said this paraphrase, who has made this paraphrase, and this is important for prelims point of view, because you never know, based on this or the backdrop of this, the question could be in the polity, question could be in the polity, the laboratories or the phrase, the laboratories of paraphrase, the paraphrase laboratories of democracy was said by which among the following, which among the following. So it could be among the following, it would be our Indian former Supreme Court judges or Chief Justice of India, and then it could be the former US Supreme Court Justice Louis Brandeis, wherein he has reasoned that yes, states are not just the, not merely laboratories of democracy. So who has said this? It is a former US Supreme Court Justice who has said, that is the Louis Brandeis has said that the laboratories of democracy states. So now we will look at the state's limitation. We were talking about the state's power. Now please do understand. Now we will focus at the state's limitation. So because we are looking at the state's limitation, because India's what? Union of states. But center, a strong center. Union of states but with a strong center. So thereby when we are saying, when we are using the word key phrase, keyword strong center, definitely there would be a limitation on the state. So we will look at few of them. The state governments have taken a position of leadership, no doubt. Now what we were all discussing, or what I was trying to explain you in regards to the separation of powers and the power of the states. So definitely the states governments have taken up the position as the leadership, but they have repeatedly been throttled. That is very important. By what? By the limitations of the federal arrangement. This is very very important. And what is the existing federal arrangements in the, what is a Indian government or the Indian representative form of government in India, is the federal structure or the federal arrangement, and because of the federal arrangement, as I said, India is a union of state but with a strong center. When it is a strong center, definitely you have the limitations by the states, and it is throttled in the sense it is squeezed by the center onto the state's limitations. And that is what the state limitation is in regards to the inability of the states to access funds, thereby to structure their own welfare package. So definitely in regards to the funds, they have to first go ahead with the, when we are talking about the taxes also, the taxes now because of the GST also, it is almost in the hands of the center. The entire funding, the revenue also is now with the center. And now in regards to the accessing of the funds, in regards to the taxes, GST also, the states are squeezed, and then they have to look forward, or they have to raise their arms to the center, to their, to run or to implement their own welfare packages or welfare schemes. So that is what is now the inability of the state. So that is why I'm talking about the state limitations, because of the federal arrangements being taken up, or which is now existing in India, that is the public representatives or the representative system in India, or the people's representative system in India, or the parliamentary form of government in India. If you look at, it is a federal arrangement, and that is actually has some kind of inability of states to access funds. And not only that, we have seen that states have been prevented easily and swiftly making payments for purchase of healthcare apparatus. Now we are getting back to the COVID-19, such as ventilators and also personal PPE, that is personal protective equipment. So now again focusing in regards to the state limitations on the backdrop of COVID-19, or to handle the pandemic COVID-19. Definitely the funds what we are talking about, the welfare schemes, now the funds in regards to the health scheme, that is to health crisis, that is in regards to containing the COVID-19 or the pandemic COVID-19. So the states have been prevented, that they are not easily being given money easily or swiftly. The center is not making payments to the states to purchase the healthcare apparatus such as ventilators and personal protective equipment. So definitely the states are limited, the powers are limited now, and states accessing of funds are throttled by the center. And now especially in regards to the ventilator, purchasing of ventilators and PPEs, that is personal protective equipment. And we have seen definitely a disruption in the supply chain. Definitely we have seen the disruption in the supply chains because of the national lockdown, because of the social distancing. We have experienced across the states, across the country, we have seen that there is a disruption in regards to the supply chain. And this is not just in regards to the essential commodities and services, but also in regards to the production and distribution also. We have seen the entire supply chain disruption in the supply chain. And this disruption of the supply chains in regards to the essential goods, and also in regards to the production and the distribution system itself, has placed the states in a position that they are facing the grave economic uncertainty. And because of, look at it, because of this supply chain disruption, because of the national lockdown, no doubt the national lockdown was accepted by the states, no doubt. I'm making a point here, I'm not contradicting my own statement, I am explaining my statement, that no doubt the states have also accepted. In fact, before, today's prime minister addressing to the nation, many states have already in advance gone ahead with extending their national lockdown 2 weeks further before the center has announced. But there is a disruption of supply chain. So that supply chain, whatever the disruption is going ahead, is the responsibility of the center along with the states to make sure that the supply chain disruption is moved away, and then there is normalcy in the supply chains. Please do understand, there is normalcy in the supply chain. So definitely because of that, because of the disruption in the supply chain, the states are in a position of grave economic uncertainty. Why? Because again, when we are talking about grave economic uncertainty because of the supply chain disruption, the point here is the funds. The funds which are supposed to, states are supposed to get from the center, are being squeezed and given, are being throttled and given, because the GST, the tax collections, are totally into the ambit of the center. So that is making difficult the states, that they are in a state of grave economic uncertainty, and that is one of the state limitation. And these limitations, whatever we have discussed now, are the urgent need to decentralize administration. This is again very important keyword or key phrase for the prelims and mains point of view. This is a key word for the prelims I am talking about, and also in regards to the mains point of view. So the need of the hour is now what? Decentralizing administration. Please do understand here, this is very important, a concept what we are talking about, a reformation, reforms in the administration, reforms in the federal structure, reform in the federal arrangement itself. Please do understand, reform in the federal arrangement itself, reform in the parliamentary form of government itself, or parliamentary form of government in India. What is that? The need of the hour is to decentralize administration. It has to be like India is a union of states, but not with a strong center. Okay, at this moment it is important. Again, when we take up another topic, probably then when we are making a point, probably then it could be that union of states with strong center. Then at that moment, so it depends from situation to situation. While you are looking at the question in the prelims, and also while you are writing an answer in the mains, depends upon the situation. So you need to understand the question which is given in the prelims or mains very thoroughly and then answer it. Now the urgent need, because of the limitation in regards to the funds and on regards to the disruption of the supply chain, the need of the hour is to go ahead with the decentralization of administration. And now, because we have seen the states limitation, now we will look at the concept of Indian federalism, which is very important for the prelims and also for the mains point of view, in regards to the way the center and the states are going ahead with invoking many acts on the backdrop of COVID-19 or the pandemic situation. The constitution creates two distinct levels, or it has created, that is one at the center and one at the states. That is what a federalism is. That is what federal arrangement is. One is at the center and the one is at the state. And this dividing the responsibility into two layers is actually been mentioned in the 7th schedule of the Indian Constitution. And this is very important for the prelims point of view, because we do forget a small, I mean, as I repeatedly say, that whatever the civil servant aspirant misses the focus, or there is a chance that the ability of the civil servant aspirant doesn't focus on few areas, then the ability, the UPSC will focus on those areas wherein you have lost your ability to focus. Please do understand my statement. Wherein the civil servant aspirants have lost the ability to focus on few areas, the UPSC will focus on that areas wherein you have lost your ability to focus. So that is very important, and that is in regards to the prelims point of view, this separation or the responsibilities between the states, or the two, the state and the center, or the two layers which have been created or divided between the both state and the center, is mentioned in the 7th schedule. This is important, 7th schedule. And the union government, as stars the matters of national importance, such as foreign affairs, defense and airways, to whom? To the union government. So as we were talking about the two distinct levels or the division of the responsibilities between the state and the center, so we have just put forward the national importance matters relating to the national importance are with the union government. So now in regards to the pandemic situation is also the national importance. Please do understand. So thereby the pandemic COVID-19 also falls under the ambit of the union government, such as foreign affairs, defense, airways, and now in regards to the pandemic situation is part of the union government, which is with the center. And when we look at the responsibilities which are vested with the states, are issues like the public health, because health is with the state subject, and not only in regards to the public health, but in regards to the sanitation, agriculture, public order and police, all these are being vested with the state government. all these are vested with the state government. So what are those? Health, sanitation, agriculture, public order, and police. So all these are the responsibilities which are vested with the states. And then in regards to the union government, what we are talking about, that is in regards to the national importance, that is in regards to the foreign affairs, defense, and the airways. Foreign affairs, defense, and the airways, and also what I mentioned in regards to the pandemic or the health crisis situation is also now the part of the union government. And then this federal architecture, which is called as a bicameral parliament, or by what is a federal arrangements. It is a bicameral parliament or it is a federal arrangement. And this bicameralism is the creation of two distinct chambers, as we have in regards to the center, that is the Lok Sabha and the Raj Sabha. The Lok Sabha and the Raj Sabha, this bicameralism which we have at the center, that is the Lok Sabha and the Raj Sabha, and then many of the states are also going ahead or does have the two bicameral structure even in the assemblies, that is in the state, that is in regards to the member of legislative assembly, and then assembly, and also the council, and then MLC also. And then if you look at the center is accorded with the power to tax all income. That is what the problem is with the states now, because of the GST which has come into existence, has been implemented. The entire goods and services tax, the entire revenue is with the state, with the center, and then the center will decide in regards to the apportionating the funds to the states. So that is the power which has been accorded to the center in regards to the taxes, in regards to the power to tax all incomes. But when it comes to agriculture, income, then that is it is regards to the states, and to levy indirect taxes in the forms of customs and excise duties. So in regards to the power to tax all incomes, indirect taxes, customs and excise duties are with the center, and in regards to the agriculture, it is the power is vested with the states, and the states has the sole power in regards to tax the sale of goods which are entering into the particular state from one state to another state, or from another state to the particular state. So to tax the sale of goods rest with the, or it is accorded to the states, and the states were guaranteed fiscal dominion. Fiscal dominion for what? So that they can enable to mold their policies according to the needs of the people. So whatever the expenditure they have, so the states have been guaranteed to go ahead with their expenditure depending upon the policies, depending upon the needs of the people, depending upon the exigencies of the people's requirement of the particular state. The states have been given the authority, or they have been having the dominion, that they can go ahead with molding the policies as per the needs. And the Supreme Court, in the case that is SR Bommai case versus Union of India, has said that the center treats states as appendages. So this is very important. That means Supreme Court has mentioned, has given in a statement in the SR Bommai case versus Union of India, how the center treats the states. The center treats the states as appendages, that is as a supplement to the center, not as coordination, or it is not in tandem with the center. It treats the center treats states as appendages, and this statement is made by the Supreme Court, in the SR Bommai versus Union of India. This is again very, very important in regards to the prelims point of view, which among the Supreme Court has said that the center treats states as a mere appendages, was mentioned in which among the following cases. So it is SR Bommai versus Union of India. And also the 14th Finance Commission also made a recommendation in regards to the center state. So what is the recommendation made by the 14th Finance Commission? It has said that as the states do not have much of funds to go ahead with the demands of the particular states, the welfare schemes to be taken up. So the 14th Finance Commission has recommended the center to increase the total tax revenues from 32% to 42%. So definitely there is a shortfall, or there is a squeeze in the funds, or the liquidity, or the revenue with the states to handle or to go ahead with the implementation of the welfare schemes which are essential or which are the demand of the particular state people. So the 14th Finance Commission has recommended, and this is again very important, which among the finance commissions have recommended the the state's share has to be increased from 32 percentage to 42 percentage. It is 14th Finance Commission. And the creation of goods and service tax, which I was repeatedly saying, which is far from achieving its core uniformity, because the entire what you say the revenue is in the hands of the center, the control is with the center, and then the uniformity has rendered nugatory in the sense unimportant or insignificant, that the internal sovereignty vested in the states. So the whatever the sovereignty is vested internally to the states is insignificant and it is unimportant because of the implementation of the GST. Please do understand, here we are talking about the Indian federalism. We are talking about the Indian federalism. So what are the impact because of the federal structure or because of the federal arrangements, and because of the goods and services tax we have looked of the union. This is very very important, and this could be a question again because of the situation what the states and the centers are facing on the backdrop of, or because of the pandemic COVID-19. You could being given a same what do you say the statement or kind of similar statement and then ask you to comment or explain or discuss. And by what I would say is the by striking at the, or else the constitutional federal edifice has made the very survival of the states. What is the constitutional federal structure? It is the federal edifice. So the constitutional or India's constitutional federal edifice has made the very survival of the states dependent on the grace of the union. Comment or discuss. Are you all listening to me? Please do understand the way we are trying to find out the various questions, analytical and factual, for prelims and also for the mains point of view. So my explanation is for sure that you will be benefited not only for prelims 2020 but also for the mains descriptive, wherein you will have in-depth understanding and knowledge for the mains also. And concluding this is that I would conclude this in regards to the decentralization of power. In regards to the decentralization of power, I would conclude by the crisis of the kind of COVID-19 has shaped the will to show us that India needs greater decentralization of power. Please do understand this. It's a blessing in disguise, I think so. What is a blessing? That is India needs greater decentralization of power. What is that? Is a blessing is that there is a necessity that India needs greater decentralization of power. But the disguise is in the form of COVID-19. Until then, we are not thinking about the decentralization of power. That administration through single central executive unit is unsuited. So what it says is whatever the strong with the strong center is unsuited to its diverse and heterogeneous polity. So in regards to this, that you can talk about that the decentralization of power is required. And again, when there is a scenario that this center has to have the powers to handle various national importance or national internal security or national security, then probably this center has to be strong. So it all depends how you are making the statement or your answer when the question is being asked, whether it is demanding from you that the states, or there is a need for the greater decentralization of power, or there is a need for centralization of power with the states, or states have to have more powers. So we have definitely looked at the two topics which are very very important for prelims mains. So please go ahead with liking, subscribing and hit the bell button when you're watching the video, that is let's crack UPSC CSE English. And if you haven't subscribed the Let's Crack UPSC CSE English channel, please do subscribe using my code SBT10, that is Sandeep Bhushan Thummala 10, because you will get definitely 10% discount on the original amount. And then please go ahead with subscribing for 24 months, because 24 months you will be getting an opportunity or the privilege of subscribing 24 months, because I've been repeatedly saying that you're actually paying 12 plus 1 month, that is 1 year plus 1 month, but you are paying for 13 months, but you are being getting the privilege of a subscription of Unacademy for 24 months. And whoever or haven't downloaded the Unacademy app, please do subscribe the Unacademy app. And then you can also be part of the special classes. You can also be part of the Unacademy special classes, and then you can be later on look at the standard or all the courses under the not only mine. You can also, once you subscribe the Unacademy app, you can go ahead with all the special classes wherein all the courses are into existence. So you will have the courses not only in regards to editorials and analysis of the editorials and articles, but also you can go ahead with all the courses. So please make sure that you are subscribing using my code SBT10, or else go ahead with downloading the app of Unacademy and then be part of Unacademy special classes. Thank you very much. See you tomorrow at this time.